The Massachusetts Supreme Court has now come out with its decision in the Karen Reed double jeopardy appeal. And this is something that we've broken down already before. We've broken down the arguments, the case law as it relates to the double jeopardy issue. And we've been waiting for months to see what the Massachusetts Supreme Court has to say about these issues. Are they going to agree with brother counsel or not? Well, now we got the opinion. I went through it. I'm not going to read the entire opinion for you, but I am going to point out certain things in the opinion that I have to discuss. And some of them, quite frankly, I may disagree with. So we are going to be doing that in just one moment. Before we do that, there's some other things I have to discuss. Number one is that last night I was invited onto a show. I went on a show with some other attorneys and we discussed the Karen Reed case. Well, there's another attorney that was supposed to appear with me on that show. His name is Mark Federer. You may have heard of him before. And about a week and a half ago, he sent us a text saying, I'm sorry, guys, I'm not going to be able to make that show. And okay, we're not going to push him and pry into his personal life why he's not able to make the show. If he can't make it, he can't make it. Well, now I think we've all gotten the answer why he was not able to make the show last night. And that is because he is now the newest addition to the Karen Reed defense team. So we are probably not going to be hearing much more from Mark Federer in terms of his legal analysis on this case. But I have some good news for you. You don't have to worry because I'm going to be there with you the entire time. And you can just turn to brother counsel for the legal analysis, for the objective legal analysis. I have not been hired by Karen Reed's defense team just quite yet. And please don't hire me. You got enough attorneys there. Let me stay objective. Let me stay outside. And that way someone can cover this case that will give the legal analysis that everyone's looking for. So that's in terms of Mark Federer. Number two is that, as you know, I was saying months ago when I first heard about this motion, when I first covered this motion, when I first heard this appeal, I was saying right away, do not appeal this. I was telling Karen Reed, if they can hear me out there, do not waste your money and time on this appeal. And in fact, I'll even pull up for you the episode in which I did that. See that right there? Episode 141, right there directly. Don't appeal. Can't get any more explicit than that. And that was way back in November. And I laid out the reasons why an appeal is just a loser. The double jeopardy claim is not going to win. And I've explained it. I laid it out for everyone. And I said, look, if you care about Karen Reed's bottom line and she has a very expensive defense team, you're not going to be wasting all this money on going through this appeal because it's going to lose. I showed you very clearly in the case law why you're going to lose. So that being said, there were some side bets that were made about this appeal. And some other people out there owe me some money. So you know where to find me. And I'm expecting some PayPals. So that's all I'll say about that. All right. Well, anyway, moving on to the actual opinion. So here we go. There is a lot to unpack. And I know I like to keep these as short as possible and to recap these very quickly. But there's just really a lot to unpack. And there's some very, very interesting things, rational and logical things that we have to work out as we're going through this opinion. So just bear with me, but there's some really, really interesting things that we have to talk about. Okay. So the first thing we're going to talk about is the argument, which I think is less exciting because I want to get this out of the way. And I've been saying this, I've been maintaining this from the beginning, that there's different arguments that they made why double jeopardy should attach here. So remember, double jeopardy attaches for one of two reasons. Number one is if you have been acquitted. If you're acquitted of a crime, well, then they can't bring you to trial again. That's the very basics of double jeopardy. Everybody understands that. So the first argument that they made in the Karen Reed case was, well, these jurors after the fact, after they already discharged and were home, they said, hey, we all acquitted her on charge 1 and charge 3, and I'm willing to sign an affidavit to that effect. So if we really acquitted her already, let me just tell you that now, even though we're not in court, we're not in the deliberation room, but my affidavit should be good enough. And look, let's get all the jurors to submit the affidavits, and she's acquitted. And therefore, since she's acquitted on charge 1 and charge 3, you cannot bring those charges again because that's double jeopardy. That was one argument. Argument number two was, at least let's do a post-trial inquiry and bring the jurors back and ask them what their verdict was on charge 1 and charge 3. And that was the second argument. And then if they do say that, yes, we all agree that she was supposed to be acquitted on count 1 and count 3, well, then she's acquitted. And if she's acquitted, double jeopardy attaches to at least count 1 and count 3. That was the first argument. The other argument that was made in Karen Reed's case was the fact that if a mistrial is declared and it was improper for that mistrial to be declared, well, then double jeopardy could attach as well. So if this is the defense does not want a mistrial, let's say. The defense wants an acquittal. And therefore, they're not consenting, and they never requested it. And now this mistrial was just declared by a judge inappropriately and improperly. Well, then that's not fair for her to have to go through trial again if we never agreed to this. And that what I thought was a more interesting argument. That was the more meritorious argument. So what we're going to do in terms of this opinion, even though the Supreme Court, they flipped it. They discussed the first argument last and the mistrial argument first. So we're actually going to be looking at the end of the opinion first, because I'm just going to kind of dispose of this argument right away, because it would never, in my mind, held too much weight anyway. So let's just go through this quickly. So you see number 2, this is page 26, and this is how it goes. The defendant separately argues that she cannot be retried on count 1 or count 3, regardless of whether the mistrial declaration was proper. That was the first part of the opinion, which we're going to get to, which is a lot more interesting. Trust me. All right. So she contends that post-trial information from 5 deliberating jurors indicating the jury was deadlocked only on count 2 and had unanimously found her not guilty on counts 1 and 3, effectively amounts to an acquittal of those counts. And since there's an acquittal, guess what? That's where double jeopardy attaches. Alternatively, she asserts that the trial judge abused her discretion in denying a post-trial inquiry to verify these accounts of juror deliberations. We examine each contention below. So first, they're going to talk about the claim of acquittal based on juror disclosures. Right afterwards, we're submitting affidavits. So trust us that we really acquitted her on count 1 and count 3, and don't even bring us back to court. So they first very easily get rid of this argument by saying, exactly as we've mentioned a few times before, that a verdict has to be received in open court. So here we go. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. That's Massachusetts Rule of Criminal Procedure 27A. So it has to be in open court. Sorry, you can't just submit an affidavit afterwards and say this was really our verdict. It's got to be returned in open court. Continuing down. Although the defendant has submitted affidavits claiming the jurors reached an agreement on counts 1 and 3 during deliberations, the only statements made in open court, which is required, reflected the jury's inability to reach unanimous verdict. That's what the notes indicated. So your affidavits can't come afterwards and fix everything up. You got to do it in open court. Okay? So that is, here we go. Okay, so that is in terms of being in open court. Now, the defendant then argues, you remember this, that you care more about form than you do to substance. Who cares if the formality of coming to court and saying what your verdict is? That's just some sort of formality. Don't raise form over substance. The defendant nonetheless argues that any lack of formality in the jurors' intended dispositions of counts 1 and 3 should not prevent those dispositions from taking legal effect. It's just a formality, so who cares? However, no, the Supreme Court disagrees with that. However, the requirement that a verdict be returned and affirmed in open court is far from a mere formality. It's not a mere formality, and they go through explaining why it's not a mere formality. Requiring a jury to publicly affirm the verdict in open court thus serves a vital purpose and ensures that the verdict agreed upon in private truly reflects the unanimous and deliberate judgment of each juror under public scrutiny rather than a tentative compromise. So it's not just a form, it's not just formality. It's important to actually have your verdict read in open court. Okay, so that's what takes care of that argument. Now, what about, okay, so just bring the jurors back. And this is what a lot of people are arguing. Well, what does it hurt? Just bring the jurors back. Well, again, if you look at the case law that talks about when you are allowed to bring the jurors back, it's very clear that it's not appropriate in this case. So here we go. Request for post-trial jury inquiry. Finally, we consider the denial of the defendant's request for a post-trial juror inquiry. Generally, a judge is not obligated to investigate jury deliberations unless there is evidence that jurors were exposed to extraneous information or demonstrated racial or ethnic bias. So you'll all remember the Alec Murdaugh case where there was allegations of jury tampering, and that is, again, an extraneous influence. That's an outside influence during the deliberations. So if there's some sort of affidavit filed by a juror saying that someone was tampering with the jury and feeding them information that was outside of the trial, then that's a problem. Then you do bring the jurors back. What about if there's racial or ethnic bias that was injected into the deliberations? If that happened, then also you bring the jurors back. That was the only situations which the case law allowed you to bring the jurors back, not in this situation. So here, the defendant concedes that the affidavits do not indicate exposure to extraneous matters or juror bias that would suggest her right to an impartial jury was compromised. That was never the argument here, right? So if that was never the argument, then there's no reason to bring the jurors back. So here we go. Additionally, the limited exception for juror testimony concerning mistaken verdicts only results in alteration of a verdict where there has been no opportunity for outside influence. It's another quote that if there's opportunity for outside influence, where all these jurors been the past couple months? Who have they been watching? Have they been watching Brother Counsel? And now all of a sudden they're saying, oh, you're right, I made a mistake about this. Well, then that also changes the situation. So these are all reasons why it's very easy for them to get rid of the other argument, which I always said was not really such a great argument anyway, about that they already came to a verdict and they just didn't record in an open court, and let's just bring them back to ask them questions. Let's just do that. So that was very easily disposed of. Okay. So now let's get to the more exciting and interesting area here. And that is if the mistrial was declared improperly. Was an inappropriate way that Judge Cannoni declared the mistrial. So so here we go. Now, a lot of the background I'm not going to go into because you probably already know the background, and people that have been following this case know exactly what happens. I have to go explain everything that happened in this case, and that's what a lot of this opinion does. So we don't have to do that. But let's get into this part. Additionally, the judge rejected the defendant's argument that declaring a mistrial was improper. She noted that defense counsel had twice requested the Tui Rodriguez instruction, the final step preceding a mistrial, and raised no objections nor made any request to be heard when the mistrial was declared. Now, you will all remember that I'm just going to pull this down for 1 second because I just want to make this point. You will all remember that the case law is very clear that there's 3 different ways that you can argue that the defense cannot argue that there was a mistrial that was declared inappropriately. That was number 1, if they requested a mistrial. If you're the defense and you request a mistrial, then you cannot argue then later that it was inappropriate for the judge to declare a mistrial. Number 2, okay, well, that's very simple. Was there a request in this case for a mistrial? No. Okay, let's move on to the next part. The next part was there consent? Did the defense consent to a mistrial? How do you determine whether the defense consented if they didn't request one? Okay, so there's 3 different ways, right? Request, consent, and then the next one is manifest necessity. So let's go to consent. How do we know if the defense consented to a mistrial? So we've explained ad nauseum. The case law is crystal clear that if the defense does not object to a mistrial being declared, that means that they consented. If they consented, it's treated as though they requested it. And therefore, you cannot argue afterwards that it was inappropriate and it was improper, and therefore double jeopardy should attach. If you consented, that's the end of the analysis. It's very clear from the case law. The only times that we ever found where the defense failed to object and the courts found that that was not consent was when it really literally came out of the blue. It absolutely wasn't during deliberations. It was just all of a sudden the judge walked into the courtroom and said, I'm declaring a mistrial. Oh, you go home. And then everyone just sitting there like, whoa, what just happened? And you didn't object in that situation. Okay, that was one situation. Another situation is where you had a very, very young attorney trying his first case, I believe, and the judge was screaming at that attorney and sanctioning him for such a bad job that he did. And the judge declared a mistrial. In that situation, also, the Massachusetts courts have found that's also, you can't expect a person who's being berated by a judge and it's his first trial to object in those situations. But when you have seasoned attorneys and there's already been 2 notes sent out saying that they're deadlocked, and now you get another note and you know exactly what's going to happen now because you're seasoned attorneys, you know exactly what's going to happen. Even if the judge doesn't tell you beforehand, oh, by the way, I'm going to declare a mistrial, you know exactly. You know what's going to happen. You know the rules. You have to assume that you know the rules. And you had an opportunity to object. Now, some will argue, well, where's the opportunity? They didn't have any opportunity to object. Well, they did have an opportunity to object because, number one, while Judge Cannoni is saying she's going to declare a mistrial, you could have said, Your Honor, if you don't want to do it in front of the jury, you can say, Your Honor, can we have a sidebar? I need to object about something. Or when she dismissed the jury and they were busy talking for a couple of minutes about the scheduling. If you really had this deep desire to object, you would have lodge your objection after the jury was dismissed and say, Your Honor, I do not agree with that. I'm making my objection on the record. I don't want this mistrial. Okay, so you're right. There wasn't a lot of time, but for seasoned attorneys like this, you had enough time to make an objection. And the case law is clear. It's crystal clear that in this situation, if they did not object, that means that they consented to the mistrial. Okay, and if you want to see all the cases about that, I've cited them in my previous videos about this, and it's very clear. Okay, so really, if the Supreme Court wanted, I think they could have done this, and they should have done this. This opinion could have been 2 pages. Okay, and it would have been like this. There was no request. And because they failed to object, that means that they consented, the case law is clear, and we don't even have to move on to manifest necessity. Because manifest necessity, you only have to move on to if the defense can argue that they didn't consent to this mistrial. And I know that a lot of the free Karen readers are upset about this, but it's just the law. That is what the law in Massachusetts says. They had opportunity to object. These are seasoned attorneys. They could have lodged their objections, and they didn't. And that's the end of the analysis. It could have been a 2-page opinion. But for some reason, the Massachusetts Supreme Court decided to analyze this using manifest necessity. Okay, and that's the beginning of my issues. But then how they actually analyze this, I also have some issues with. Okay, so let's pull it back up and let's see what they're saying. Now, so they started off right here. This is actually pretty good. Raised no objections, nor made any request to be heard when the mistrial was declared. The judge remarked that defense counsel were no shrinking violets during the trial, making it unlikely that when counsel heard that the jury was at an impasse for a 3rd time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. She also concluded that in any event, the mistrial was manifestly necessary given the jury's repeated statements of deadlock. Okay, so that was just saying what happened, and they could have used that. The Supreme Court could have said, okay, we're going to analyze this under that part. But for whatever reason, they decided they're going to analyze this under manifest necessity because it's more cool. All right, so here we go into the discussion. So we're not going to go through the entire discussion, like I told you. They talk about double jeopardy and how important that is, and okay, yada yada yada. But let's move on to the actual parts where they're going to talk about manifest necessity. So let's start from here, even though I highlighted a little bit later. The decision to declare a mistrial is entrusted to the sound discretion of the trial judge. Trial judges receive such discretion to avoid the possibility of coercive measures being used to force a jury agreement, thereby protecting the fairness of the proceedings. You don't want the judge to coerce the jury into a verdict. You want the verdict to be fair and that the jury is coming to it on their own. In evaluating whether a trial judge abused his or her discretion in declaring a mistrial, a reviewing court considers whether the judge carefully explored alternatives to a mistrial and whether counsel were given full opportunity to be heard. So this is what you need to prove for manifest necessity. Okay, so we got through the request part. Let's say, for argument's sake, there was no consent here. So now we have to move on to, well, was there manifest necessity? Which means that even if the defense attorney is screaming that objections and not agreeing to this mistrial being declared, nevertheless, if there is manifest necessity, then the judge can still declare a mistrial and it will be proper. But what do you have to do in order to prove that you did not abuse your discretion as a judge? Number one, you had to carefully explore alternatives to a mistrial. That's number one. And number two, you have to give counsel full opportunity to be heard. Full opportunity to be heard. So those two things have to be met in order for a judge to not be considered that they abused their discretion. And that's from Commonwealth versus Taylor. It's in a bunch of cases. It's a lot of cases. If these principles were followed and there is no claim of insufficient evidence to support a conviction, double jeopardy will not prevent the defendant's retrial. Okay. Here we discern no abuse of discretion in the trial judge's decision that the jury were at an impasse and that a mistrial was manifestly necessary. So there's no abuse of discretion. Judge Cannoni did not abuse her discretion that the jury was at an impasse and that a mistrial was manifest. It was manifestly necessary. Okay, so then it goes through, after all the deliberations and after the notes, let's talk about their exhaustive review and the diligent consideration, yada, yada, yada. Okay, so you can tell pretty much that the jury was at an impasse. Now the question is, okay, the jury's at an impasse, but Was the two requirements fulfilled in order to show that you have manifest necessity to declare mistrial? Number one, full opportunity to be heard. Number two, careful considerations to alternatives. Now, you will remember this case, Fuentes versus Commonwealth. I spoke about it a number of times in the video because it's a very, very important case. Let me just X out of this for just 1 second so you can just concentrate on this. Fuentes versus the Commonwealth is a case about manifest necessity. And my opinion about that case has always been, after I did the research on this, is that Fuentes was wrongly decided. It was just used in wrong analysis. Why do I say that? Because what happened in Fuentes was that there was an objection. Okay, so that's number one. There has to be an objection in all these cases, which is why Karen Reed case is not even close to even getting this double jeopardy. Okay, but there was an objection actually lodged in the Fuentes case. And there was no careful consideration to alternatives in Fuentes. There was none of that on the record. But what happened, what the courts did in Fuentes, this court did, I think it's the Supreme Court, what they did is they said, hey, let's think about what alternatives there could have been. So even though the judge did not carefully consider the alternatives, let's think about what alternatives we can think about. And let's see if that would have been reasonable or not. And that's the analysis that they ran through in Fuentes. Now, what's the problem with that? If at the end of the day, hindsight is 2020. So why can you say, okay, look, looking back at the case, there's no reasonable alternatives anyway. So let's just say that, okay, even if that judge in Fuentes would have carefully considered alternatives, it wouldn't have mattered. The reason why I have a problem with that is the following. There's another case. Okay, we'll come back to this in a second. Actually, we'll come back to this in a second. There's another case called Stewart. Commonwealth versus Stewart. And in Commonwealth versus Stewart, this is what the court said. We shall be deferential to the trial judge's exercise of discretion in ruling that a manifest necessity exists for a mistrial, only if it is clear from the record that the judge has given careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding. And this is quoting this case, a Supreme Court case, Barton versus Commonwealth. So here we have Supreme Court saying that it has to be clear from what? Hindsight? No. It has to be clear from the record. There has to be a clear record that the judge gave careful consideration to the available alternatives. So that's what Stewart says. It says you cannot do this trick in Fuentes. You cannot go hindsight is 2020 and say, well, let's think about what alternatives could have been possible anyway. No. It has to be clear from the record. That's what the judge has to do on the record. So this is the law in Massachusetts. And all of a sudden, Fuentes came recently without saying clearly, we are overruling Stewart. We are overruling Barton. They didn't say that. They just said, yeah, let's analyze it under, this new idea that we're coming up with. So that's why I thought that Fuentes was wrongly decided. Now, I was wondering if they're going to address this, because the legal scholar in me wants this issue put to bed. You can't have two different standards. Is the standard that it has to be on the record, or is the standard that even if looking back and discussing the alternatives and deciding that there's no reasonable alternatives, that that there you can say that there's no double jeopardy? You have to have one standard. So I really wanted them to say that. I wanted them to argue that Fuentes should be overruled, and this should be the law, Stewart, which was the law in place in Massachusetts for a while, since 1982. So that wasn't done. And the reason why we see consistent quoting to Fuentes is because it's clear that this court is using that type of analysis. They're using Fuentes to say, let's talk about what alternatives could have been thought about and could have been used, and let's see if that's practical in this case. And then we'll see whether that, whether the judge Cannoni even needed to do that on the record. Now, it's clear that Judge Cannoni did not do that on the record. She did not carefully consider other alternatives. Now, they do kind of make a little bit of a mention that, maybe there are some other alternatives that she thought about, but this is really the way that they are approaching this. They are approaching this using Fuentes. 2007 case and saying, let's talk about in hindsight what alternatives could have been used. Okay, so that was my first issue with this opinion. All right, but anyway, let's move on. And again, I'm not saying there's anything wrong with it because they do have Fuentes. They do have this case that says you can do it this way, and that's how they're doing it. I just think that Fuentes is wrong because if you look at the other cases, Stewart and the other ones, which were before 2007, it's clear that it has to be done on the record. Okay, that's all. All right, so let's continue with this analysis. Okay, so they're talking about how, after all the deliberation, it was very clear that the jury was at an impasse. The defendant contends, here we go. The defendant contends that despite the jury's deadlock, the trial judge failed to adequately consider alternatives to declaring a mistrial. Yet, as discussed, the trial judge did consider and pursue such alternatives. So, they do talk about some alternatives that the judge considered. Well, which ones? Well, let's see. After the first note reporting deadlock, the judge instructed jurors to continue their deliberations. Okay, so let's just take that for a second. Well, here's an alternative. The judge said continue deliberating. Now, is the Supreme Court now telling us and telling all the judges in Massachusetts that as long as you send the jury back for one time to consider deliberating, that means that you considered other alternatives, and therefore this prong will be met as part of manifest necessity? Is that really what this court is actually suggesting? I don't think so. That can't be. Just by sending them back to deliberate further. That's not a reasonable that's an alternative. We send them back to deliberate more. No, that doesn't make sense, right? Every single case is going to be like that. So you wouldn't even need to make, all you have to say is just send them back for one deliberation and forget about alternatives because you just satisfied alternatives by sending them back for deliberations after one note. That happens in every case, right? If there is a deadlock, they're always sent back for after one note, right? Okay. So that can't be, right? So now, okay, let's continue. After the first note reporting deadlock, the judge instructed jurors to continue the deliberations. Okay, we spoke about that. After the second note, the judge issued the Tui Rodriguez charge. Okay, so is that the alternative? Now, there is a case, which we spoke about, where the judge was discussing declaring a mistrial. And the attorneys suggested instead to read the Tui Rodriguez charge. There is a case like that. And in that case, the judge says, I'm not going to read the Tui Rodriguez charge. They've been deliberating enough. I am declaring a mistrial. Okay, so there, in that case, contemplating giving them a Tui Rodriguez charge was a reasonable alternative. That is what the courts found, the reviewing courts. That just contemplating giving the Tui Rodriguez charge, that is considered enough of a alternative. That's a careful consideration of alternative to declaring a mistrial. But the difference is that there, the discussion was, the consideration was, do I declare a mistrial or not? The judge brought it up, said, okay, I'm thinking about declaring a mistrial. Who wants to say anything about it? Let's consider the different options. And that's when the attorney said, let's do the Tui Rodriguez. And the judge says, I understand why you want it. We're not going to do it. Okay, at least there was a consideration when the judge was talking about a mistrial. After the second note, let's be honest here. After the second note, was anybody talking about a mistrial? Was Judge Cannoni considering a mistrial at that point? Very clearly not, right? Nobody's brought it up. Nobody suggested it. The judge didn't suggest it. She just said, okay, we got the second note. What do you want to do? And they said, okay, let's do the Tui Rodriguez. And I think Lally said, no, not yet. We shouldn't do the Tui Rodriguez. Okay, so the only consideration was whether to read the Tui Rodriguez charge. At that point, they were not considering a mistrial. So you're right, after the second note, they were talking about the Tui Rodriguez charge, but there's no clear indication at all, definitely not on the record, that Judge Cannoni was considering a mistrial. But it seems that the Supreme Court is saying, well, that's considered a reasonable alternative. That's considered carefully considering another alternative by just giving the Tui Rodriguez charge. So now let's take that to its rational conclusion. The logical and rational conclusion, therefore, is, are you telling me that in every single case where there is a Tui Rodriguez charge, that automatically satisfies that prong of manifest necessity, that's carefully considering another option, as long as you get the Tui Rodriguez charge, you're done. You carefully consider the other alternatives, because that's really creating a completely new law in Massachusetts. Anytime a judge gives Tui Rodriguez, that means that they are considered to be considering other alternatives. Or what I think the more rational way, and the way that I think that this manifest necessity was written and these requirements were given, was that when the judge is considering a mistrial, when that thought comes up, when that discussion happens, that's when the judge has to say, okay, let's consider everything on the table right now. I'm thinking about a mistrial. What else is on the table? That, I think, makes a lot more sense. And that did not happen in this case at all. All right. So therefore, although they're trying to seems like they're trying to say alternatives were pursued, there was definitely not, I think, within what the case law requires. It's when the judge is considering a mistrial. Okay. All right. Now let's move on. After the second note, the judge issued the Tui Rodriguez charge. It was only when the jury submitted their third report of deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without their consent. Now, this is a very important part, okay? That's why this video is going to take a little bit longer, because we have to really digest this and understand this. And then we're going to take the logical and rational steps and conclusions that they're trying to make here. We know that once the judge gives a Tui Rodriguez charge and the jury comes back with another note saying they're deadlocked, the judge is not allowed to send them back for deliberations. She cannot require them to deliberate further. Now, if they consent to, they could, but she cannot require them, order them to continue deliberations. All right, so now we have the Tui Rodriguez charge in this case, and then we have this third note. Okay, so Tui Rodriguez is not an option anymore. What other alternatives are there? What other alternatives are there? So this is what part of the argument that the Supreme Court is going to make now, is that there's really nothing. There's really nothing. And I know what you're thinking, and that's what they're going to talk about. So this is a very important part. Okay, that the judge declared a mistrial. Nonetheless, the defendant argues that the judge should have inquired whether the jury had reached agreement on any of the charges. Had the judge done so, the defendant asserts, she would have discovered that the jury had agreed on counts 1 and 3, allowing for a partial verdict. So this is the argument. The argument is, well, at that point, you can't send them back for further deliberations. We know that. That's the statute. You're not allowed to send them back for further deliberations. But you know what you could do? You can ask them if there is a partial verdict. Now, that discussion definitely did not happen on the record, right? So if you're following Stewart, that was not done. And this is why I'm saying you see that they're using Fuentes here, because now they're playing hindsight now. And they're saying, well, would that be a reasonable alternative? And now they're going to say, no. Here we go. Had the judge done, okay, and they said, we disagree. We disagree. That was not a good option. Well, why not? Isn't there a rule about that? And that's what we're talking about. That's Rule 27B, right? We have Rule 27B. 27B, the Massachusetts Rule of Criminal Procedure, says what? It says that it gives a trial judge discretion to require a jury to return a verdict for charges on which they have unanimously agreed before declaring a mistrial. There we go. A judge may require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. We all know 27B. 27B says straight out that the judge could inquire. Not required, but could. So is that a reasonable alternative? Sure. So should that have been considered? Why not? Well, this is where they are going to be doing some gymnastics here. This is where the Supreme Court is going to do some gymnastics. So get ready. Here we go. What's wrong with 27B? Here we go. Here, the jury were instructed on 3 separate indictments along with 2 lesser included offenses on count 2. But the trial record offers no indication that a partial verdict was imminent or possible. So here's the first argument that they make. Remember, the jury, there was 3 charges here. Charge number 1 had no lesser included. Charge number 3 had no lesser included. Charge 2 did have lesser included, as we all know at this point. Now, was there any sort of indication on the record that there was some sort of partial verdict, that it was imminent or even possible? No, there's no indication on the record. So let's stop right there. Is the Supreme Court now saying that 27B only applies where there is an indication on the record that there's a partial verdict? Are we reading that limitation now into 27B? Is that what the Supreme Court is doing right now? Certainly seems like it. They're saying, well, the trial record offers no indication that a partial verdict was imminent or possible. Who cares? 27B says that the judge can inquire into it. There doesn't have to be any sort of indication. So are you saying it's not an option at all because there was no indication on the record that a partial verdict is imminent or possible? That's what they're starting off with. So let's continue. Okay, now they're saying how the notes, and this is where it gets into the charges, where the notes don't say very clearly that there's any sort of indication that a partial verdict was imminent or possible, right? So they go through the notes, and here we go. The third note, we know it says the charges, and this is where everybody starts talking about. Then the simple understanding of the charges is all the charges, and that is exactly what they say here. We say, again, that just what they say here, we assess the trial judge's decision based on what was known at the time of her decision, not afterwards when the jurors are saying afterwards, oh, maybe the charges meant the charges in count 2, even though the jurors didn't say that, but, maybe we can look back and say that's really what they meant. But at the time, come on, at the time when it says the charges, you would assume they're talking about all the charges. As one court has observed, allowing post-trial juror accounts to affect the analysis would create endless confusion and controversy. We can't just let jurors after the fact come back and start wreaking havoc on everything. Okay, so that's what they say here. In short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. Okay, so now again, they're trying to build up the case here, the Supreme Court in Massachusetts, that since there's no indication that there was any sort of partial verdict, so therefore what? Therefore, it's not a reasonable alternative to ask for a partial verdict. And this is what we just explained before, that they're now reading into this Rule 27B that it only applies when there is some sort of indication on the record that there's a partial verdict, which obviously does not appear in the rule at all. All right, let's continue. So we're going down till here we go. Now, we're going to talk about the coercion part. This is an important part. This is what they base a lot of their analysis on. There was a case, Roth. Okay, the Roth case and the A juvenile case, which is something that they rely on a lot in this opinion. Those two cases. It's worthwhile to look up those cases. But the Roth case, and we probably spoke about it in one of our previous videos, but the Roth case talks about a situation where there's a jury verdict and there was a charge with a lesser included. Okay, so there was a charge with a lesser included. So in that case, the jury was deadlocked, and the judge asked them for partial verdicts on a lesser included. Okay, so a lesser included of one of the charges. That is where the judge asked them for partial verdicts. That got appealed. And this is where it's important to understand this difference. It's nuanced. Person can be charged with different charges. Charge 1, charge 2, charge 3. Those are 3 charges. A judge is allowed to take a partial verdict. So if the jury says we're hung, the judge can say, are you hung on 1? Are you hung on 2? Are you hung on 3? Do you have any verdicts at all? Judge is allowed to do that. What Roth says, this case, Commonwealth versus Roth, what that says is that when it comes to lesser included, then you cannot ask. The judge cannot take partial verdicts on lesser included. Okay? And that's a very important distinction in Roth. And the same thing goes for A juvenile, which is the name of a case. All right. So the reason that Roth gives is that it's too coercive. If the judge, if after a number of notes, the jury's saying we're hung, and then the judge says, well, what about any of the lesser included? Can you guys go back and figure out whether you're all hung on all the lesser included, or you're just hung on the other charges? Like let's start breaking it down by the lesser included. That the Roth court found was too coercive. So they are going to apply that analysis to this case. The reason why this is so significant is that up until this point, the only analysis by Roth was by lesser included. Only when you have lesser included, then you cannot take partial verdicts. But if you have different charges, you could take partial verdicts. In fact, that's why we have 27B. 27B says that a judge could do that. If we throw out 27B and say, you cannot use 27B at all, well, then what's 27B doing there? Well, Roth is saying, okay, 27B is only not lesser included. But now what this case is doing is saying, wait, well, hold on a second. Hey, there's coercion here. There's a risk of coercion in this case also. after 3 notes, and now you're going to ask for partial verdicts? Well, then the risk of coercion is too high here. So listen to what they say here. In this case, the risk of coercion were evident. The risks, of course, were evident. After receiving the 3rd note, the judge was statutorily barred from ordering further deliberation without the jury's consent. As we know, right? After a Tui Rodriguez charge, you cannot send them back again. So the judge here, Judge Cannoni, was statutorily barred from sending them back for further deliberations. So now, therefore what? Well, let's see. Look what the Roth court says. Asking, and this is what they quote, they kind of mix and match it, but this is what it says. Asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial, quoting from Roth. In these circumstances, there is simply too great a risk that any resulting verdict would merely be the product of one hasty final attempt to satisfy the judge's apparent desire for some form of decision on the case. And if the judge were to inquire about the possibility of a partial verdict, by definition, any further discussion amongst the jurors regarding the response to the judge's partial verdict inquiry would itself be further deliberation in violation of the statute. So, what's the logic here? The logic is simple. What do you got here? You got after the Tui Rodriguez charge, now you want the judge to ask about partial verdicts, right? That's what they're saying. That's what the defense wants. The defense wants, all we're asking for is to the judge to ask the jury for partial verdicts. Well, the Roth case says the following. And again, that was with lesser included, that if the judge were to inquire about the possibility of partial verdicts, by definition, that means that there has to be further discussion amongst the jurors regarding the response to the judge's partial verdict. Okay, so there has to be more deliberations. That would inquire itself further deliberation. Now, you're not allowed to have further deliberations. You're statutorily barred from ordering the jury to have further deliberations. You can't tell them to deliberate further. So if after a Tui Rodriguez charge is read and the jury comes back and saying we're still hung, if the judge were to ask, this is what the Roth court says, if the judge were to ask for partial verdicts, that would automatically require discussion amongst the jurors, and that would automatically require deliberations, which is statutorily barred. So you can't do that. So what they're saying is, well, let's apply the same thing to over here. Here, Judge Cannoni, she gave the Tui Rodriguez charge, and now you have, they're hung again, they send the 3rd note, and now you want to ask for partial verdicts? Well, partial verdicts is going to require discussions. Discussions equal deliberations. We're not allowed to do that. So what they're doing, what the Massachusetts Supreme Court is doing in this case, is that now they're applying the Roth analysis, which was only applied to lesser included, and they're applying it to this case, and therefore the logical conclusion would be then that in any single case where there is a Tui Rodriguez charge read, you are never allowed to ask for partial verdicts, right? That's the logical conclusion here, because after a Tui Rodriguez, you're not allowed to send them for further deliberations. And according to the Roth case, by asking them for partial verdict, that would require discussion, that would require deliberations. You can't do that. So now what they're doing here is, you see what type of limitations now our 27B is? 27B is very simple. It's very broad. A judge can ask for partial verdicts. Now we're saying, no, you can't ask for partial verdicts. You cannot ask for partial verdicts after a Tui Rodriguez charge is read. So you have to literally, according to this opinion, you have to amend Rule 27B, Rule of Criminal Procedure 27B, and now put in this limitation that this rule is only if there is no Tui Rodriguez charge read. That's literally what they're doing here. You see my problem with this. That's the problem, because the rule does not say that at all. The rule should be taken as its plain meaning, which is that a judge can ask. Now also, you already may have been taking issue with this whole idea of Roth. That why, just by asking for a partial verdict, does that require a discussion? Why does that require a discussion? Now, I can understand perhaps by lesser included, because there's, let's say, 5 different lesser includeds, and you weren't sure exactly which ones the jurors agreed on, and maybe there's going to be require a few minutes of conversation to figure out which ones you guys agreed on. But when you have separate charges, and you all know exactly which charge you reached an agreement on, charge 1, charge 2, and charge 3, it doesn't require any further deliberations. So you can really take issue with the Roth analysis itself, saying, why is that true? Why is it true just by the fact that we are asking for a partial verdict that requires a conversation? What type of conversation does that require? The foreman can say, yeah, we all agreed. We all agreed on charge one, and then pull the jury. That's it. There's no discussions necessary. It could be, just me going on a limb, it could be that what the Roth court is talking about is that when you have lesser included and there's 5 lesser included and the jury may not remember exactly which one it is, and then they're going to have to go back and figure it out, that's going to require discussion. But you see why this doesn't really apply to this case. And again, this only applies when they're working with hindsight, which is my original problem with that, is that that's only based on Fuentes, which is contradicted by Stewart, which means that it has to be done on the record, not that we can do this hindsight business. Okay, anyway, let's continue. Thus, given the entire course of the jury deliberations and the empathetic language of the third note, the jurors were deadlocked on the charges and that further deliberation would be coercive. The judge acted with inner discretion in declaring a mistrial without inquiring sua sponte about a partial verdict. See Fuentes, again, going with Fuentes. Judge was not required to ask jury if they would consent to further deliberations before declaring a mistrial because jury had already received to a Rodriguez instruction, yada, yada, yada. Okay. For much the same reason, the trial judge's decision not to pull the jury sua sponte to confirm the deadlock before declaring a mistrial did not constitute an abuse of discretion. What about pulling the jury after the mistrial? What about that? No, that's also not abuse of discretion not to do that. It didn't constitute an abuse of discretion. A trial judge is not required to consider every conceivable alternative before declaring a mistrial. And we discern no abuse of discretion in the judge not pursuing alternatives suggested. Well, in this case, it was actually suggested. In this case that they're quoting. But in our case, in the Karen Reed case, there was no suggested because there's no discussion about it. There was nothing done on the record about it. If an alternative which was neither suggested by counsel nor considered by the judge is later developed, okay, then you can't fault the judge. There at least, but in these cases, they had a discussion about it on the record. These other cases that are being quoted in this opinion. That's the very important difference here. This is why they need Fuentes so badly. This is why the Supreme Court, the Massachusetts Supreme Court, needs Fuentes so badly, because none of this was done on the record. This is all using hindsight and using this interesting analysis with Roth. And now also changing and limiting Rule 27B, which according to this opinion now, Rule 27B is extremely limited. Let's continue. The defendant further contends, separately from the availability of alternatives, that it was an abuse of discretion to declare a mistrial without first notifying defense counsel of the content of the third note and allowing an opportunity to be heard. Now, this was all, you remember that when that third note was read, they didn't call the lawyers in first and read the note, which is always done. I mean, that's the normal way to do things. Okay, now, we've discussed this already. This is not a winning issue either, because even though that's the right way to do it, but if you don't do it that way, that's also okay. So, first, okay, it is it is worth noting that the trial judge discredited defense counsel's claim that he lacked such an opportunity, as we spoke about. When the third note prompted the mistrial, defense counsel neither objected nor expressed any dissatisfaction, even when the parties remained in the courtroom to schedule a subsequent status conference, which is, I think, really, that's the issue here. That's why this appeal gets denied, because there's no objection. But they're using it as more of an opportunity to be heard, which is using it under manifest necessity. Again, the convolution of we're convoluting consent and manifest necessity. That's what I keep finding in this case, which is a little frustrating, but they all do it. In any event, there is no indication that inviting defense counsel to participate in the third round of consultation would have produced any fruitful alternatives. See Fuentes. See, there's no indication that inviting defense counsel would have produced any fruitful alternatives. Again, that's in hindsight. That's why they have to rely on Fuentes, because Fuentes, everything's in hindsight, even though Stewart requires you to do it on the record. Continuing, furthermore, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict based on the content of the jury notes. Now, listen to what they say here. This is, again, there's a lot to unpack here, so I'm sorry for going so long, but this is important. Listen to what they say here. Furthermore, nothing suggested that defense counsel would have requested an inquiry into the possibility of a partial verdict. So they're saying now, that note itself would suggest that the defense would not even want to inquire into the possibility of a partial verdict. You know why? Look at footnote 12. See how it says footnote 12 there? So you got to go to footnote 12. Why not? Listen to what they say here. It is difficult to imagine that a competent defense attorney, upon learning that some members of the jury firmly believed the evidence proved the elements of the charges beyond a reasonable doubt, right? Remember, that's what the note said. Some of us firmly believe that the charges are proved beyond a reasonable doubt. Some of us firmly believe the other way. Now, if you're a defense attorney, you say, some of my jury firmly believes that my client is guilty. Am I going to want to take a partial verdict? Maybe on some of the charges, all of them agree. That I don't know if that's and that's what they're pointing out here. Any competent defense attorney would request that the jury be instructed to return verdicts on any charges where agreements had been reached. As other courts have recognized, the defendant may have a tactical reason for not requesting the trial court to question the jury about partial verdicts. Now, this is something that we've spoken about before, and that is that between you, me, and the lamppost, the defense attorneys were quite happy with a mistrial. Okay, every single defense attorney in the country is happy with a mistrial, and you just hope the prosecution doesn't bring it again. And the same thing goes for this case. This was something after the fact that they realized, hey, maybe we can make an issue out of this. Okay, and that's what happened in this case. They were quite happy with the mistrial. That's why they had that press conference afterwards. Everybody kind of knows that. It's just that if you technically can have some sort of argument to argue that you really weren't happy with it and just you didn't have an opportunity to object and try to make these interesting arguments to make the case go away, you'll try to do that. But we all kind of know in the back of our minds that the defense was happy with a mistrial. I mean, obviously everybody wants an acquittal, but when you're a criminal defense attorney, a mistrial is a win. All right, but anyway, continuing. While the more prudent course might have been to read the third note to counsel and provide yet another opportunity to be heard before declaring a mistrial, the trial judge did not abuse her discretion in failing to do so. Okay, and that's just in terms of reading the actual note to the attorneys before you call in the jury. So that's not really such an important part. In sum, we conclude that the trial judge acted within her discretion in declaring a mistrial without first inquiring about a partial verdict or offering defense counsel an additional opportunity to be heard. You hear what they say here? Additional opportunity to be heard, which again, I take a little bit of issue with that because the other times about the Tui Rodriguez and sending the jury back to deliberate after the first note, that's not when you're considering a mistrial. Come on, let's be honest here. All right, so it's when the judge is considering a mistrial. That's when you have to give opportunity to be heard. All right, but they're kind of spinning it with that. Oh, it's an additional opportunity to be heard. Considering the length of jury deliberations, the judge's prior efforts to encourage consensus, and the increasingly empathetic tone of the jury notes indicating deadlock, it was clear the jury had reached an impasse. Now look what they say here. Okay, there's another quote from Fuentes versus Mass. But look what they say here in this footnote. Okay, this is what really grabbed my attention. Because we conclude that the trial judge acted within her discretion in determining that declaring a mistrial was manifestly necessary, and that's what this whole opinion is. This whole opinion is to try to explain how really there was manifest necessity to declare this mistrial, and it wasn't abuse of discretion, even though there was no real consideration on the record of alternatives, careful consideration for alternatives. That wasn't done. But using Fuentes, we can kind of use hindsight to try to figure out whether it would have been reasonable anyway to pull the jury, and they decided that that's too coercive. And now by doing that, they're reading limitations in 27B. I think that this opinion really, you have to really understand what this opinion is doing to 27B. It's completely creating a totally new 27B. And they didn't need to do that, by the way. They totally did not need to do that. But that's what they're doing. They're using Fuentes, and then they're saying, well, that alternative would have been reasonable. And now you're basically, okay. Anyway, so because we conclude that the trial judge acted within her discretion in determining that declaring a mistrial was manifestly necessary, we do not need to address the defendant's alternative argument that the defense counsel did not consent to the mistrial. You hear that? Well, we decided already that there was a manifest necessity, which means that even if you didn't consent to the mistrial, still there was a manifest necessity to declare the mistrial. So therefore, we're not even going to consider or figure out whether your argument about whether you consented or not has merit or not. Now, I think this should have been just the opposite. There should have been a 2-page, like I started off, there should have been a 2-page opinion explaining how they're failing to object, according to Massachusetts law, equals consent, period. And then have a footnote there, because we conclude that you fail to object, and that means that you consented to the mistrial, we do not need to analyze this under manifest necessity. And then if they would have done it that way, then they wouldn't have come up with all of these very, very interesting analysis and completely destroying 27B and changing 27B and reading limitations into 27B that are not there. And, this analysis itself is not the greatest, as I pointed out. So I think that would have been a lot safer for them to do and actually would have been more correct. So, but that is essentially the opinion here. So that is going to be it. As I've said, I've been calling this from the beginning, although I was not expecting them to just ignore the straight out case law that says that in this case, failure to object is consent, and then run through this interesting analysis with respect to manifest necessity, and then using Fuentes, even though Fuentes is against Stewart. I mean, all the arguments that we spoke about. So it turns out, I think that it was the right decision, but I think the reasoning is a little off. So that's going to be it for now. Thank you all for tuning in. If you haven't yet, please subscribe, like. You can wish Mark better or the best. And fortunately, we're going to be missing his analysis, but you can always come back and tune in to Part of the Counsel, and we will see you next time.